It's made from hope.
Hello?
Which case did you? Oh, there it is. There it is. This is SU 2026 CR 183, State of Kansas versus Noah Graham Boaz. State appears by the County Attorney Larry Marchinsky. Mr. Boaz appears in person, and counsel Michael Stutman appears via Zoom. Do we have an announcement in this matter, counsel?
Yes, Your Honor. I believe we have the discovery in full. I visited with my client. He is currently in a sober living at Amber Hope. He is an outpatient. I'm going to explore a plea agreement with Larry on this, and I think we'll probably have this resolved we have one more setting, Your Honor.
And what date would you like this set over to, Mr. Stutman?
Oh, I know on this following, you're usually going to be doing the next docket on probably the 10th of September.
I can do that. Do you want the same time, 9 o'clock, or do you want a different time?
I'm sorry, I can't. I've got a murder case going that day.
That's fine. Any Thursday works. So
very good. If we could have, I could do it the following Thursday.
September 17th, what time?
And if that would work, I can do it at this time.
Okay.
Whatever the court has.
Court will continue this matter to September the 17th, 2026 at 9 a.m. at the defendant's request.
Thank you so much.
Thank you. And I believe that's all you had this morning. Is that right, counsel?
Yes, Your Honor.
Thank you.
Thank you, sir. Have a good week.
You too. I've got SU 2026 CR 161.
Thank you, Your Honor.
Thank you. State of Kansas versus Clay Hunter Burgess. Looks like O'Hara's on there. State appears by County Attorney Larry Marchinsky. Mr. Burgess. There's a lot. I see Mr. Burgess is present by Zoom, as is counsel Mr. O'Hara. Is there an announcement in this matter, counsel?
Your Honor, we're going to request to set it over one more time. I would ask that same September 17th date that Mr. Stedman just had, if possible.
And does 9 o'clock work for you as well, counsel, or do you want a different time?
9 o'clock would be great.
Court will continue this matter to September the 17th, 2026 at 9 a.m. at defendant's request.
Thank you, Judge.
Thank you. And I believe that's all you had as well. Is that correct?
Yes, Your Honor.
Thank you, counsel. Mr. Seitz, are you ready on your matters?
Yes, Your Honor.
Do you have a preferred order or announcements on yours?
Yeah, Your Honor, Carlos DeBeer or Brian Cooley wouldn't happen to be in the courtroom, would they?
No.
Okay. Your Honor, my office did receive some contact from Miss Cooley yesterday, and I believe we were able to confirm yesterday that an appointment at Sumner Mental Health Center has been scheduled. I would request a continuance of approximately 30 days, give her some additional time to get engaged in treatment, to contact my office, discuss these cases.
Do you have a date in mind?
Yes, Your Honor, September 10th at 9 o'clock.
Since she's been in touch with you, I'll continue this matter and mental health. I'll continue this matter to September the 10th, 2026 at 9 a.m. at defendant's request.
Judge, for the record, I just want to, I'm sorry, but I do want to lodge an objection. This is a bond appearance. She was bonded out of jail. It properly appears her to be here.
I'll do it as a must appear. I'll note your objection. I know she's residing in Sedgwick County, and transportation is probably an issue. She has been in touch, but I will make that a must appear, Mr. Seitz.
And I'm sorry, what was that date, sir?
September 10th. Those matters. Mr. DeBurr's case, the only other one you had, Mr. Sights?
Yes, Your Honor. Your Honor, Mr. DeBure, my office has heard from. He was recently picked up and bonded out. He did miss his last court hearing due to a voluntary treatment in Wichita. I'm kind of in a similar position here where I'd like it if he was here today and if he and I had a chance to correspond, but there's been some issues. I've had a chance to discuss this case with the state a few times. I would request a similar continuance to September 10th at 9 o'clock. I understand if it will be set as a must appear.
And I do know that I ordered him to immediately contact mental health, and my recollection was he did reach out to mental health.
That's my understanding as well, Your Honor.
And Ms. Beggs is on here. I see that. And he has been in touch with you. So, state.
I'd have to make the same objection, Your Honor. He just bonded out a few days ago. It properly appeared, ordered him to be here this morning. I understand everything that we're saying and what you're going to do, but for the record, the state does have to object. I mean, we put these bonds in place for a reason, and if they don't show up, that's pretty concerning. So, and he just bonded out of jail, what? Well, I guess it's been 6 days ago now, but we all know the status of Mr. DeBurr, the status of this case. So I just need to make the formal record that, he was granted a bond. It ordered him to be here today. He fails to appear.
I'll note the objection. I'll continue this to September the 10th, 2026 at 9 a.m. and also a must appear. I know the driving priority was mental health and he has touched base with them. So we'll see where that goes.
Yes, sir.
If anything, I believe that's all you had as well, right, Mr. Sights?
That's correct, Your Honor. Thank you.
Thank you, counsel. Just a second. Just screwed that up. Do we have any other attorneys on here? Who? We'll call Mr. Stewart's case. Mr. Stewart, if you want to come to the. This is SU 2026 CR 102, State of Kansas versus Christopher Wade Stewart. State appears by County Attorney Larry Marchinsky. Mr. Stewart appears in person and pro se at this point. And Mr. Stewart has filed a motion in this matter. Have you had an opportunity to review that motion, Mr. Marchinsky?
Yes, Your Honor.
Do you have any objection to his motion? It's my understanding you're just not wanting to have probation. You're just wanting to serve your jail sentence and be done.
Yeah, I'm moving to Wichita, so I want to just be done with it before I go.
Okay.
Judge, he's also asking the court to modify his sentence.
I'm looking for that.
Well, we've had a discussion, Mr. Stewart and I helped him prepare that document that he filed. I told him that he didn't need to be very specific in his request paragraph, but he wants to serve his sentence, but he's also asking the court to consider a lesser sentence. I can tell you that there is a virtually identical motion that's about to hit on Melissa Stewart's case as well. She has been asking for the exact same things. I basically advised her that I would recommend whatever the court was willing to do for Mr. Stewart, that I would recommend the same for her when that got there. I advised Mr. Stewart that had we originally been negotiating this case for a jail sentence, I might have been willing to consider less than 30 days. I was recommending the 30 days with the idea that it was going to be suspended to a term of probation. This is a mutual combat situation between Mr. and Mrs. Stewart. Ms. Stewart is asking that the court consider amending the sentence down to 2 days, give her credit for time served and close the case. I told Mr. Stewart that I told him that I would not object to a modification to 14 days. Upon our discussion of what Melissa was asking for, he also asked that the court maybe consider 2 days for him as well. So I just advised both folks. I wasn't sure what you would do with it, but it is a mutual combat domestic situation. There's been no issues between the two of them since they've both been on probation. I appreciate Mr. Stewart's veracity and wanting to get this taken care of so he can move on with his life. So that's really kind of my position, Judge. I don't have an objection to, of course, modifying his sentence to let him do the time. And from there, I just kind of leave it to you what you think is most appropriate, sir.
Okay. And did he do has he had any jail time on this at all?
He was arrested. You'd have to ask Mr. Stewart. I know he was
I
arrested,
was
but I
there
think
for a
it was
day.
just,
Do you have maybe one day done?
Right.
Do you have any comments you want to make before? I'm going to grant the motion. It's just a question of how many days at this point. I appreciate maybe the recognition or the need to move on and not try to do probation. So I appreciate that. But do you have some comments you want to make regarding how much time you want to?
Um, I, you know, my big thing is, trying to get everything moved. And my roommate, she's, you know, can't take care of herself. I'm helping her. So I'd have to move both of our things, to Wichita. So I just, whatever you see fit. I mean,
Are you prepared to commence service of that sentence today?
I was asked to do it when I could turn myself in on Sunday, so I can have this weekend to finish buttoning some things up. Cause I've got a bunch of stuff to pack and I got to pull a fence down and,
Okay, I'm going to modify your sentence as requested. I'm going to modify your sentence, obviously to eliminate probation and revoke and remand you. And then I'm going to commute 23 days off of your sentence. So you've got 7 days.
okay.
Allow you to check into the jail Sunday at what time?
Sunday evening sometime around 6 or 7, somewhere in there.
So that would be Sunday, August the 16th at
About
9 a.m.
9 a.m.
What, there you want to do it in the evening?
Yes, cause
What time? I apologize.
probably about 7 o'clock would be good.
At 7 p.m. So you'll
Yes.
report and do 7 days. I commute your sentence to 8 days, give you credit for the one you've done. So you're gonna do 7 and then be done. So you'll go in on the 16th at 7 p.m. and then you'd be released the next week, same
Okay.
time. All right?
All right, thank you very much.
All right. Thank you, Mr. Stewart.
Thank you, sir.
Mhm.
You guys have a good day.
Sir, what's your name?
He was filling out an application.
Oh, did you get your application filled out? If you want to come on up, this is SU 2026 CR 76, State of Kansas versus Joseph Patrick Gleek. Mr. Gleek, you have several charges here. This is count 1, driving under the influence, class B, non-person misdemeanor, carries up to 6 months in jail and up to $1,000 fine. It does have a mandatory fine of $750. There's count 2 of possession of marijuana. That's also a class B person misdemeanor, carrying up to 6 months in jail and up to $1,000 fine. Count 3 is possession of drug paraphernalia. That also is a class B non-person misdemeanor, again, 6 months in jail and $1,000 fine, potential penalty. And then the final count is speeding. You do have a right to an attorney to represent you in this matter. If you want to continue to hire an attorney, I can do that. I do note that you have filled out an application for a court-appointed attorney. I'll look at that in just a second, sir. Mr. Marchinsky, do you know if Mr. Kalik qualifies for diversion?
I mean, based on the facts of the charges, yes, sir. I'd have to look at his criminal history to verify that we've charged it correctly and that there's no other prior DUIs. But as the court knows, we got in trouble for that. So Greg's been being very diligent about reviewing that. So presuming how he has it charged and based on these charges, yes, sir, this would be a diversion eligible offense.
All right. So you've heard that announcement from him. And again, if you thought, hey, I want to pursue a diversion, I don't necessarily want to have to reimburse the court for a court-appointed attorney, I would give you continuance to explore that option if you want. Do you know what you want to do with regards to this case?
Yes, I would like to obtain counsel.
Okay.
Uh,
Are you wanting me to review this?
If you can, yes,
Okay,
sir.
give me just a second. We'll take just a second. It does appear that you qualify. We'll appoint Austin Fallsgraf to represent you. I'm gonna have to set this over to give him an opportunity to receive that appointment.
Your Honor, do you have a phone number for Mr.?
He's gonna give you a card and he's gonna give you your next court date. And I know that it looks like you reside well, on here it said Oklahoma City.
Yes, sir.
If you'll touch base with him, you may be able to appear by Zoom instead of trying to drive up here. So I'm gonna give you a few weeks. What I'd like to do is continue this to September 3rd. You need to reach out to him next week.
Okay.
He's not gonna have the paperwork until probably Monday.
Good.
And that'll be at 11 a.m.
Yes, Your Honor.
All right?
Yes, sir.
There's nothing further. This hearing's concluded.
All right.
Like I said, reach out to him early next week so you can start discussing your case.
Okay. Thanks, Judge.
All right. Thank you.
Have a good day.
You too.
I'm sorry, Judge, what was that date real quick? I was reviewing this.
September 3rd. I know that, well, is that going to be a jury week?
That's it. Yeah, but that's okay.
But I mean, I don't expect much to go on in this case, so that's why I picked that. So. That takes care of everybody in the courtroom. So let's start up here. Who's the guy? Okay, next case I have is SU 2022 CR 268, Trinell R. Caples. State appears by County Attorney Larry Marchinsky. Mr. Capel
Yes,
is present by Zoom. Okay, the screen's a little ways away, so I'm having trouble reading names. This is a bond appearance. Give me just a second. Oh, this is an old case. Mr. Caples, this is a case from 2022. Count 1 is speeding. Count 2 is driving while suspended. That's a Class B misdemeanor carrying up to 6 months in jail and up to $1,000 fine. Count 3 is possession of marijuana. Again, that's a Class B non-person misdemeanor carrying up to 6 months in jail and up to $1,000 fine. Count 4 is possession of drug paraphernalia. That's a Class B non-person misdemeanor. Again, up to 6 months in jail and up to $1,000 fine. Count 5 is no proof of insurance. That is also a Class B non-person misdemeanor that carries up to 6 months in jail and up to $1,000 fine. It does carry a mandatory minimum $300 fine on a first offense. Count 6 is an expired or no registration. That's an unspecified misdemeanor. I believe that carries it's got an unusual penalty provisions regarding up to 6 months in jail and up to $1,000 fine, I believe. Count 7 is display of an illegal license plate, and that's an unspecified misdemeanor with the same potential penalties as the expired registration. You do have a right to an attorney in this matter. If you want to continue to hire an attorney, I would grant that. If you would like the opportunity if you cannot afford an attorney, the court would appoint one to represent you. I'll inquire again, Mr. Marchinsky, is this a situation where he might be diversion eligible, or do you know?
In reviewing it briefly this morning, Judge, it does appear to me that it would be, yes, sir.
So that might be, if you wanted to explore the diversion opportunity with the county attorney's office, I'd also continue it for that purpose. If you want the court to appoint an attorney, you would need to fill out an application for me to review. Do you know what you want to do regarding this matter, Mr. Caples?
yes, sir. I just want to get it resolved. I don't need no lawyer or nothing like that. I just want to get it resolved.
I don't know that any of these carry mandatory jail time, so I may be able to do it without a waiver of attorney. Obviously, the distance in doing this by Zoom creates issues. Is the state requesting a jail sentence on any of these charges?
I mean, I typically do on a driving while suspended. I think it has actually a mandatory minimum 5-day jail sentence and a mandatory minimum $100 fine.
Oh, yes, you're right. I apologize. I missed that offense as I was scanning through this.
I would, again, I understand and appreciate what he was saying. I would suggest maybe he wants to call me. Typically, I mean, if he
Yeah.
just says, "Oh, I want to plead guilty today," then my answer is, "Okay, here's the fine for the speeding. Here's the fine for the driving while." I mean, if he wants to call me, we can work out a disposition. He would be just looking at this again, diversion eligible. Might be a little bit expensive, but on the same token, I would typically dismiss a few of these
Sure.
charges in a pled negotiation. So I'll defer to him what he wants to do, but I would suggest that maybe he request a continuance and call me.
Mr. Caples, you've heard that announcement. You might be able to
Yes,
work out a plea bargain. The other
yes,
thing is,
I would love to work out a plea bargain. So I'm just trying to get it resolved,
right,
sir.
right. What I'm going to do is I'm going to give you a continuance of a few weeks, give you a chance to visit by phone. You'll need to call Mr. Marchinsky's office. We'll give you that number here shortly. Set up a time to visit with him by phone. The other thing we need to do, Mr. Marchinsky, if the driving on suspended is going to be, that's the one that requires a jail sentence, and I would need to, you're not necessarily required to serve the jail sentence, but I would
Right.
still need to do a waiver of an attorney with him. If part of your plea negotiations involve that, would you please forward, and I can make sure you have the waiver of attorney form. Mr. Caples, I think maybe in order to give you time to do that, I would like to continue this 3 weeks to give you time to talk to him and get all the paperwork put together for this case. Are you,
Yes, yes,
does
sir.
that work, September 3rd?
Yes, sir.
We'll
And
continue this.
would it be a problem me being on Zoom call?
No, I don't have a
Okay.
problem doing it by Zoom if you work out a plea bargain that is just to paying fines.
Yeah, I would love to do that.
Or something along that. If your plea bargain entails any kind of probation, I prefer that be in person, but I'll let you visit with Mr. Marchinsky regarding that. Give me just a second.
Is that going to be September 3rd at 9 a.m. again, sir?
Yeah, we'll do that at 9 a.m. Well, hold it just a second. Do we have any Monday dockets coming up?
Mr. Caples, my telephone number is area.
Where's off?
Do you have a pen and paper?
Oh, one
We
second,
could
one
do
second.
August 31st. Let's do this. I'm going to move him to that pro se docket on August 31st. We'll have a little more time. that
Okay,
morning.
what's the number?
Go
ahead, Mr. Marchinsky.
Thank you, Your Honor. Mr. Caples, my phone number is area code 620
620.
326
Okay,
7941.
okay.
And I would suggest you call them this morning. They can advise you how to get a diversion application. And I've been very, very busy. So it's at least 2 weeks to get an appointment with me, even a phone call appointment. So call as soon as you can so we can get that scheduled. Okay.
I'm gonna call soon when I get off.
Okay.
And Mr. Caples, I'm going to continue your case to August the 31st, 2026 at 9 a.m. to give you a chance to get that worked out with the county attorney's office.
31st. Okay.
All right?
All right. Thank you.
If there's nothing further, this hearing is concluded. Thank you.
All right.
Who else do we have up there? Who's the Shiloh Chase? Okay. Is that Mr. Smith? Mr. Smith, I've appointed Tanner Dillon to represent you, and he will be here at 11 a.m. So I'll call your case at 11 a.m. All right?
Okay, thank you, sir.
Mhm. I don't have it.
I'll be able to go back there, these, man.
Mr. Chase, your attorney's not here yet. Looks like I have two. Oh, I guess we could do Nicholas Baker. Where's my? Is this Mr. Baker?
Yeah,
Okay. This is SU 2026 CR 200, State of Kansas versus Nicholas
I'll wait.
Lee Baker. Mr. Baker, you've been arrested. Complaint has been filed alleging count one, burglary of a non-residence. That's a level 7 non-person felony, which means it carries anywhere from 11 months up to 34 months in the custody of the Secretary of Corrections. Count 2 is a theft, felony theft, a level 9. That means it carries anywhere from 5 months up to 17 months in the custody of the Secretary of Corrections. You do have a right to an attorney to represent you in this matter. If you cannot afford one, a court would appoint one upon proper application. Do you know what you want to do regarding an attorney in this case?
just the court appointed attorney.
Okay, you'll need to fill out an application regarding the court-appointed attorney, and the court would review that application, appointed attorney to represent you in this matter if you qualify. So you need to fill that out. The jail will give that to you. I need to review your bond in this matter. It looks like your bond was set at 25,000 cash or professional surety on the bond conditions that you have pretrial bond supervision by court services with repath monitoring. Are you able to make bond at $25,000?
I don't think so.
I know there's a co-defendant in this matter. Mr. Marchinsky, do you know who was appointed to represent his co-defendant?
Give me 1 second, Your Honor. I can certainly tell you. Oh, okay. Yes, sir. Sorry for that delay. Mr.
Yeah.
Fabre was the appointed counsel for the co-defendant in that case, Your Honor. That would be Mr. Zach Deffenbaugh in 26 CR 199.
So I will, you need to get the application put together, but it's likely I'll be appointing Tanner Dillon to represent you. So I need to continue this a week. State have a position on bond in this case. I don't remember what I did on bond on the other co-defendant.
Mr. Deffenbaugh's case went pretty fast and hot. He already pled
Oh.
guilty in that matter. He had a couple of issues going, so he pled guilty in this case to the theft portion of it, and he has already been, I believe, released on the probation or dealing. He might be waiting PSI in the other matter. I mean, based on the charges, I don't have Mr. Baker's criminal history right in front of me. Maybe I do. Yes, I do.
Are you on probation anywhere, Mr. Baker?
No.
Judge, I don't see any immediate failures to appear.
Yeah, I initially just set these kind of high to get him in front of me and then consider something else. Unless he's got significant history, he's going to be presumptive probation. Where do you reside, Mr. Baker?
In Sedgwick County?
And so if I give you a bond, you'll be able to make court appearances here in Sumner?
Yes, sir.
Yeah, Judge, burning through this, I see one failure to appear. That's back in 2015. Other than that, I don't see much. There's a couple of things on here, but I don't see anything that's gonna
Right. I think with,
trigger a special rule or anything at this point.
and I think with the bond conditions, he would be supervised on this bond. So, Mr. Baker, I'm going to modify your bond to allow an OR bond, but I'm going to leave the conditions the same. You'll need to report immediately to court services for pretrial supervision on bond upon your release. You
Okay.
do need to fill out your application for a court-appointed attorney. And I'm going to set your bond appearance time at 11 a.m. on August the 20th.
Okay.
But you need to fill out the application for an attorney first, okay?
Okay.
And then you need to report to court services today. Do you have any questions?
No, sir.
All right, this hearing's concluded. Good morning, Mr. Moody.
Good morning.
Give me just a second.
Good morning. Sorry, I gotta make sure my mic's on.
It's all right. Mr. Moody, do you have any of yours? I think you've only got a couple this morning.
Yeah, Judge, I've got two this morning. Shiloh Chase looks like he's via Zoom.
We'll take that
Um,
one up first. He's been on here a little while. That's SU 2026 CR 141, State of Kansas versus Shiloh Jader Chase. State appears by Larry Marchinsky. Mr. Chase appears by Zoom, as does counsel Robert Moody. Do you have an announcement in this case, Mr. Moody?
Thank you, Judge. Yeah, so Mr. Marchinsky in our negotiations, Mr. Marchinsky did reach out to me. One of the things that we've been kind of waiting on is for him to be able to speak to the alleged victims in the case, which he did, but the alleged victims required or requested at least a follow-up. And I believe Mr. Marchinsky has that scheduled for August 21st. And I think once he has that, then we can probably finalize negotiations. So I would ask for 2 weeks. I believe that's the 27th date at 9:30.
Judge, obviously, we're not really calculating speedy or anything at this time, but I did advise Robert that that should be a state's continuance. Everything he said is correct. We've been working towards a plea. I had a conference with the alleged victim, Mr. Rick Chase. He wanted to discuss it and asked that we have a follow-up meeting. Robert is correct in that we have that tentatively scheduled for the 21st. So I agree with the continuance, obviously have no objection, and technically it probably should be on me because it's my delay in getting contacted with the victim and stuff.
I'll continue this to August the 27th, 2026 at 9:30 a.m. I'll make a note. It's at the state's request to discuss that with the victim or try to finalize some plea. So we'll set it over. Thank you, Mr. Chase, for appearing this morning.
Thank you.
And Mr. Lowe is here in the courtroom. This is SU 2026 CR 54, State of Kansas versus Vance James Lowe. State appears by County Attorney Larry Marchinsky. The defendant appears in person with counsel Robert Moody via Zoom. Do you have an announcement in this matter, counsel?
Yes, Your Honor. I did receive an offer from Mr. Marchinsky. I did sit down and go over that offer with Mr. Lowe. I still think I need to continue discussions or negotiations with Mr. Marchinsky. I've not had a chance to reach out and do that yet, but I would request that August 27th date as well for those reasons.
Okay. Court will continue this matter to August the 28th or 27th, 2026 at 9:30 a.m. at defendant's request. Thank you, Mr. Lowe. And Mr. Moody, is that all? I think that's all I have for you this morning.
That's all I have as well. Thank you, Judge.
All right. Thank you, counsel.
All right. See you, Larry.
Take care, Robert.
Looks like we have. I've still got a couple of nines I need to clean up. SU 2026 CR 222, State of Kansas versus Clifford Lee McClure. Looks like maybe that's a bond appearance. No, what the heck? Oh,
Judge, this was one of the ones that was a little funky in that let's see, we're talking about McClure. His
right.
actually showed him to appear. One of these fellows was ordered to appear on Sunday. Okay, Mr. McClure's bond did properly appear him last Thursday, but as we well know, the courthouse was closed. We had taped signs on the windows advising folks that if their case was last week to come this week. These are pretty significant cases.
Right. And we checked in a lot of people at the door last week. Again, signage was everywhere. Everything was set this morning. If people appeared, they knew they needed to be back this morning. So I don't have any doubt that he's just failing to appear on this. Was a relatively low bond to begin with.
Yeah, Judge, he was released on a $1,000 OR bond. This alleges trespass, criminal damage to property, and an attempted theft. Sheriff's officers found him and Mr. Henry attempting to cut parts off of some farm equipment out in the country. He is on a $1,000 OR. Again, that's been ineffective to get him here. We're not sure if he showed up last week, but he's not here today. The state would ask the court consider revoking that OR bond and maybe issuing a warrant in the amount of $2,500. These are all misdemeanor charges, I believe. I don't think there's any felonies in here.
Yeah, he's failed to appear. All authorize a bench warrant, $2,500 cash or professional surety. The next case I have is SU 2026 CR 221, State of Kansas versus Charles Aaron Henry.
Judge State's arguments would be the exact same. Mr. Henry was the fellow that got actually ordered to appear on a Sunday. So that was a little funky. I didn't know what we were going to do. I don't like it when the bond form is not correct and when they order the defendant to be here. And Mr. Henry's bond form does order him to be here last Sunday. But with that idea in mind, to my knowledge, he hasn't called my office. He hasn't called the clerks. And he doesn't appear today. So I'm just going to have to make the same request, Judge. He's the co-defendant in the last case that we just discussed. And I'd request the same $2,500.
And there's probable cause in this case, so I could issue a warrant even with that mistake. Defendant FTA, I'll authorize a $2,500 bench warrant in the amount of $2,500 cash or professional surety.
Thank you, sir.
The last case I have at 9 is SU 2023 CR 44. That is State of Kansas versus Brian Lee Belleville. What are we on for?
We're on for a bond appearance for a probation violation, I'm pretty sure. Get in here.
Yeah, it was set last week as well. Did we hear from, I have not reappointed Mr. Favre. It looks like he's got multiple active warrants out of other counties.
I was going to say, Judge, this is a multiple PV at this point. I know that we had a probation violation back in December. I believe we've had one prior to that too, but I'm not thoroughly through the court file. We have had prior warrants in this case. It does appear that the bond form, he is out on a $10,000 professional surety bond. I haven't heard anything from the surety. It ordered him to be here last Thursday, the same colloquy that we've had regarding last Thursday. But with the prior warrants, the idea that this is a probation violation, the state would have to just ask that the court consider revoking the $10,000 professional surety bond, issuing a new bond, and whatever you think is appropriate. I would probably ask for like $50,000, considering it's a multiple PV and a failure to appear. But I would defer to the court what you think is appropriate, sir.
I'll do a bond forfeiture. I'll authorize a bench warrant in the amount of $25,000 cash or professional surety.
Thank you, sir.
And
Would you like any other conditions like GPS or repath or anything, considering the multiple failures to
my
appear?
hope is it's high enough he sees me before anything. He's got other issues he's dealing with, it looks like, in other counties.
And I would
Yeah,
note the current PV allegations, Judge, are that he failed to report when we're ordered and that he failed last PV we had, you ordered him to a 30-day jail sanction, which he never appeared for and served. So that's the current PV.
Let's do GPS monitoring as a bond condition. And we'll be in recess till 10 o'clock.
Perfect. Thank you, sir.
was figuring.
I know that two of mine are running late. I heard
Okay.
from them, so.
So this is Mr. Redding, and that's just going to be an informal announcement.
Yeah.
Do you know what date? You want to continue that to?
4 weeks good for you. Can I get 4 weeks, Judge?
September the 10th?
Let me make sure I'm not setting something that I'm gonna regret.
Why, that was more of a question. Why?
I'll make it work. September 10th.
We'll continue this matter to September the 10th, 2026 at 10 a.m. at defendant's request. Thank you, Mr. Redding.
Sir.
You have any other informals, Mr. Bales, that we can knock out real quick or?
Let me have a second.
Sure.
Organized,
That's
and
fine.
I will tell you.
I hit you up kind of cold when you walked in.
Hit me up and we'll start putting your case together, figure out how to get you through this. I see Miss Rivera there. She'll be, I believe she'll be a plea.
Okay.
I don't have Richard Brown today. Casey Hallowell and Kenesha Brown are my ones who are running late. Don't see Amanda Neal yet.
Who is that?
Hey Larry, are you good to go on the Rivera plea?
We might want to chat. I found out this morning that she was just arrested for a DUI in the last day or so, so that kind of changes my opinion slightly as to which we might do here. I just got notice this morning. Got an email from David Beveridge alleging that she'd been arrested for DUI in Mulvane on 8/7. He sent me a copy of her booking sheet. I haven't had any other follow-up on that. I just found out about it at about 8 o'clock, 9 o'clock this morning when I got here.
Why don't I then, can I get 4 weeks on Miss Rivera so Larry and I have some time to put our heads together and figure out what's going on here?
I don't know if she's still in custody.
No, she's on bond and we just removed the scram from her not that long ago.
And she's here.
She's present. I think the expectation was the disposition this morning, and we're not in any rush. It's a pretty light docket.
Okay.
So if you need some time to visit with her, visit with Mr. Marchinsky, we've got time because I don't think there's any 1030s.
No, I didn't see any when I was looking online.
When I did prepare an amended complaint, I didn't, Houston and I both been scrambling, so I haven't filed it yet. I need to come upstairs and swear it to the court if that's what we're gonna do.
We've got time.
Well-
If you need me to take a break for you to get ready, we can. We have time this morning.
Let me, okay, in that case, Zachary Capps, is he in the jail chair there? Or is he out?
Is that Mr. Capps? It looks like they're,
There's Capps.
give me just a second. Since he's in custody, I'll formally call it. SU 2025 CR 235, State of Kansas versus Zachary Neal Capps. State appears by county attorney. Defendant appears from the Sumner County Jail, and counsel James Houston Bales appears in person.
Judge, at this time, Mr. Capps, I was previously appointed. We had a bond forfeiture. Now, I'm back on it. I would request, September 10th as a new date so I can get together with Mr. Capps, with Mr. Marchinsky, and we can start making some plans.
All right. Court will continue this matter to September the 10th, 2026 at 10 a.m. at the defendant's request.
Mr. Capps, I'm gonna come by and try to see you, before I leave town today, if the jail will let me. So if I don't see you today, I will see you very soon so we can make some plans on this.
And if you get something resolved and need a special setting, you know, you can reach out to the court.
Okay, in that case then,
If you
why
need
don't,
some
yeah, why
time,
don't we take 5,
we'll take a recess until council lets me know we're ready. All right?
yep.
Thank you.
Hey Larry, do you mind if I run downstairs and chat with you, or do we
He
want to
needs
do
to
it
run
while
up.
we're hanging here?
I'll be up and at least, well, if you want to come down, but I need to come up on Miss Riviera to swear to this complaint.
Well, I'll run downstairs because I got more than one person to talk about. If it were just Mr. Vera, maybe, but I'm gonna run down to you.
Okie dokie.
We're back in action. This is SU 2026-CR-125, State of Kansas versus Jessica Jean Rivera. State appears by County Attorney Larry Marchinsky. Mr. Rivera appears in person with counsel James Houston Bales. Mr. Bales, you either have an announcement in this matter.
Yes, Judge, at this time, we've reached a plea in Mr. Rivera's case to a Class A misdemeanor.
And that's the amended complaint. Did you get a copy of that? You
Yes, I
heard?
did, Judge.
Okay. And what's the agreement? Is there an agreement on sentencing or just an?
Judge, we more worked out the disposition of the charges more than perhaps the fine tuning of the disposition ultimately. The state is going to recommend an underlying sentence suspended to probation. This is a Class A misdemeanor. It was originally charged as a criminal threat. I would advise the court if she was to plead guilty to the criminal threat, she probably would have been looking at a 5, 6, 7 box on the grid. The endangerment that we've agreed to, which could possibly be considered a bit of legal fiction, but we were trying to get to a disposition that worked out for all of the parties. The state is going to recommend a jail sentence underlying probation, that her court case be immediately suspended to probation. I'm going to ask the court to consider an initial period of probation of 12 months. We had a brief colloquy this morning, Your Honor. I was advised this morning when I came to work that Ms. Rivera had been arrested in Mulvane for a DUI. Frankly, I know nothing more about that case than that. But for that reason, I did amend what I was going to recommend for probation. I'm going to now add the condition that I'm going to ask the court to impose a drug and alcohol evaluation as a condition of that probation. And I am going to ask the court, just back on, I believe July 31st is when we had a motion and we removed the scram bracelet. In hindsight, I probably shouldn't have agreed to that based on what's happened since then. So I am going to ask the court to reimpose scram as a condition of her probation. However, I do understand scram as a costly device and somewhat of an onerous condition. So I would recommend that the court consider imposing that on her until she gets some treatment done. I did have an opportunity to speak very briefly this morning with Mr. Joseph Rivera, who's present in the courtroom. I believe he is supportive of our disposition. He advised me that more than anything, he was desirous of getting her into treatment. I advised him that hopefully if we got her on probation, that probation could help get her access to some of those services that my understanding is that they've struggled to get. So ultimately, your question is, what is the plea? The state is going to recommend, probably I think it would be appropriate to recommend a 6-month underlying sentence, because I think that that would be the standard number in the grid box had she pled to the felony. I am going to ask that the court suspend that to 12 months of probation. I am asking the court to consider imposing a condition of to get a drug and alcohol evaluation and to follow those recs. My personal belief from hearing things this morning is that should apply or get us into inpatient treatment, but the professionals will make that determination. And then my argument on scram. I did ask Mr. Rivera if he desired any no contact. He was very clear with me that he did not desire a no contact order. Seems like they're trying to work through their issues in their family, and I'm supportive of that. So that's all I have for you, Your Honor. Thank you.
Okay. Mr. Bell?
Judge, we would join in the state's recommendation. About the only difference in our recommendation for the against the state's recommendation would be in the timing of the scram monitor. We'd ask that if Mr. Rivera is admitted to inpatient treatment, that she be allowed to remove the ankle monitor while she's in inpatient treatment. But otherwise, Mr. Marchinsky has indeed recited the agreement. We are asking for the same thing.
All right. Mr. Rivera, you've heard the announcement of your attorney. Is that your intention this morning, is to plead guilty to that amended charge?
Yes, sir.
And you understand that you have a right to a trial by judge or jury that you're giving up by entering that plea?
Yes.
And you understand that at that trial, the state would be required to prove you guilty beyond a reasonable doubt, that you would have the opportunity to see the witnesses testify, that you'd have the opportunity for Mr. Bales to cross-examine the state's witnesses, that you'd have the opportunity to present witnesses and evidence on your own behalf, although you're not required to. You also are giving up the right to testify on your own behalf if you wanted to, but you could not be required to testify, and there could not be any insinuation that you were guilty because you remained silent. You understand you're giving up all those rights at that trial?
Yes.
You're also giving up the right to appeal any errors that might occur at that trial, any legal problems that you're giving that right up by entering this plea. Okay. And to the charge, count one, endangerment, which is a Class A person misdemeanor. How do you wish to plead?
Guilty.
And the allegations that on or about the 19th day of April this year here in Sumner County, Kansas, that Ms. Rivera, through various threats, did recklessly expose another person to the danger of Mr. Rivera during that argument, and those threats placed him in a situation where he was endangered. That's the state's factual basis. I know there's some issues that might be had with that, but you understand that's the factual basis for this plea.
Yes.
And Mr. Bales, you've reviewed the discovery and feel comfortable that that's the factual basis for the state.
Yes, Judge, the fact, this was actually my proposal to Mr. Marchinsky, so I would take responsibility for that factual basis.
Right. Court will find the defendant is knowingly, willingly, and voluntarily given up her rights to a trial herein, has entered a plea of guilty, and there's a factual basis for the court to accept that plea of guilty, and will find the defendant guilty of endangerment, a Class A person misdemeanor. Mr. Marchinsky, do you have any additional comments before I impose sentence? Mr. Bales, do you have any additional comments before I impose sentence?
No, Judge, I'd rest on my previous comment.
Ms. Rivera, this is your opportunity. If you would like to make comment to me before I make a decision on your case, although you're not required to, do you have any comments you want to make?
Not at this time.
Okay. Court will follow the recommendations. I'm going to impose a 6-month controlling sentence. I'm not going to oppose a fine in this matter, but I am going to assess the court cost, any booking fees. I'm going to assess any supervision or court services monitoring fees. I'm going to place you on a 12-month probation immediately. That means you get probation today. You'll need to report to probation today and set up your times and follow all the recommendations that they have regarding reporting. I'm going to require the standard conditions of probation, which are going to be no consuming of alcohol, and submit to testing. But I'm also going to have the special condition that you obtain a drug and alcohol evaluation, follow the recommendations of that. I am also going to require scram until such time as you enter treatment. After treatment or during treatment, if court services request the scram be reinstated, I'm going to leave it at their discretion to utilize scram in the future if they feel it's necessary. But from now until you get into treatment, I think you need to have a scram monitor. You need to stay clean. It's obvious that you have issues with alcohol and staying out of trouble. And so I think that's appropriate. I want you, when you meet with court services, to review your probation, to make sure you ask them questions if you're not sure about something, because you can't come back in front of me if you violate probation and say, Judge, I didn't understand what the expectation was. That's why you're sitting down with them to go over that. Because once you initial it and it gets submitted to me, you're saying, I understand what is expected, Judge. All right? Mr. Bales, you are appointed in this matter. Is that correct?
That's correct, Judge. It originally began as a felony as well, so I would request a State v. Robinson waiver. She's having difficulty getting funding for treatment. That's part of the reason that we're here and agreeing to this disposition. So clearly there's a financial issue here. I don't think she would have the ability to pay attorney's fees in this case.
Okay. With regard to this, I'll take notice of her application, the fact that she qualified and now she has more financial obligations, especially with the requirements of treatment. I'm going to not assess attorney's fees against Ms. Rivera at this point in time based on State versus Robinson. Is there anything further I need to address today?
Nothing on behalf of the state of Kansas. Nothing on behalf of the defense.
All right. This hearing's concluded. Good luck, ma'am. And you'll need to report to court services today.
Thank you, Your Honor.
Well, I think they're used to Zoom, but we can make sure one of the deputies can get her down there. Mr. Lloyd.
It's gonna escort you
Deputy.
downstairs to the probation office. They're gonna get you started on your conditions, okay? Do you have any questions for me?
Are you sure why they're not? Well, Stephanie's
You're
on.
gonna be okay. It's just
Stephanie's
a
on.
choice every day.
Deputy Lloyd's going to take her down and show her the probation officers. Thank you, Deputy.
Good. Ms. Brown, how are you?
This is SU 2026 CR 75, State of Kansas versus Kenesha Brown. State appears by County Attorney Larry Marchinsky. The defendant appears in person with counsel J. Houston Bales. Looking where we're at on this. Is this for plea? Is there an announcement in this matter?
Yes, Judge, we've reached a plea agreement with the state in this case, and we'd be asking to enter that today. I believe it's a misdemeanor plea.
And what is the agreement?
One moment, Judge, shifting gears here.
But I'm pretty positive we agreed to a plea to DUI as charged, Class B misdemeanor, and 1 count of possession of marijuana. Class B misdemeanor, as far as disposition, the state was going to recommend a $200 fine on possession of marijuana. Recommend the mandatory minimum fine of $750 on the DUI. State was going to recommend 6 months under suspended probation. I believe Ms. Brown is aware she has to get a drug and alcohol evaluation prior to our sentencing hearing. The state was then going to dismiss the remainder of the charges and claim upon a successful plea. I think that's everything.
Yeah, I actually just pulled up your email, and that is,
I'm reciting from memory, but I'm pretty positive.
And I know we went through this on another case. Is the drug and alcohol required on a first offense before sentencing?
Unless they've modified it, it was, I believe it is.
yeah, my experience in Wichita Municipal Court.
I think it's a great idea. I'm not saying that it isn't, but I know that we had had some discussions regarding what the actual requirement is, but I'm fine with that if we do that. And if that was what everybody was expecting to do, I'm fine with setting sentencing over to get that, because the more information I have at the time of sentencing, the better it is for everyone. So, okay. Mr. Bales, is that a correct recitation of the agreement of the parties?
Yes, Judge.
Ms. Brown, you've heard the announcements here this morning. Is that what you're expecting to do this morning?
Yes, Your Honor.
Before I can accept your plea, it's important that I go through your rights regarding this matter. You understand that by pleading guilty, you're giving up the right to a trial by judge or jury?
Yes, Your Honor.
And you understand at that trial, you would have certain rights. You'd have the right to require the state prove you guilty beyond a reasonable doubt. You'd have the right to see the witnesses testify against you. You'd have the right for Mr. Bales to cross-examine those witnesses. You'd have the right to present evidence and witnesses on your own behalf, although you're not required to present any kind of defense. You would also have the right to testify on your own behalf if you desired to, but you don't have to. You can remain silent, and we can't insinuate that you're guilty because you're not doing that. You understand all those rights at that trial that you're giving up by entering a plea of guilty?
Yes, Your Honor.
Also, you're giving up the right to appeal any errors that might occur at that trial. You understand that?
Yes, Your Honor.
And you understand that even though there might be an agreement between yourself and the state, that I'm not required to follow that.
Yes, Your Honor.
Okay. And to the charge, let's see, it's
Counts 3 and 5, Judge.
count 3 is driving under the influence, a first offense, Class B non-person misdemeanor. How do you wish to plead to that offense?
Guilty, Your Honor.
And count 5 is possession of marijuana, and that's also a Class B non-person misdemeanor. How do you wish to plead to that offense?
Guilty, Your Honor.
And the allegation or the factual basis for the plea is that on or about the 29th day of December 2025 here in Sumner County, Kansas, you did operate a vehicle. At the time you were under the influence of alcohol. It looks like the BAT was 0.08, which is the threshold within 3 hours of driving. Is that the factual basis for that plea?
Yes, Your Honor.
Yes.
And Mr. Bales, you've reviewed discovery and you're comfortable that those are the facts the state would be presenting at trial?
Yes, Judge.
And also at that same time, Ms. Brown was in possession of marijuana, and that's the factual basis for that plea as well, obviously here in Sumner County.
Yes, Your Honor.
Yes,
Okay.
Judge.
Counsel's court will find the defendant has knowingly, willingly, and voluntarily waived her rights to trial, has entered a plea of guilty on those 2 charges. Court will find there's a factual basis to accept that plea, and the court will find the defendant guilty of driving under the influence of Class B non-person misdemeanor and possession of marijuana, Class B non-person misdemeanor. State have a motion regarding the remaining counts.
Would ask the court to dismiss the remaining counts 1, 2, 4. The remaining counts with prejudice.
Okay. Court will dismiss those counts. We need to schedule a sentencing. I'll have order the defendant to do a drug and alcohol evaluation. Probably 6 weeks, we think. That's maybe the 24th of September, Mr. Bales, or the following week.
Could we go on either side of that? I am scheduled to be in a murder trial in Sedgwick County now. I'm trying to.
Do we want to go to October 1st?
I'm available.
Oops. Set sentencing on October the 1st, 2026 at 10 a.m. That will be in person here in Sumner County. Order the defendant to obtain a drug and alcohol evaluation in anticipation of that. And I know court services can coordinate a referral order to Sumner Mental Health if she desires to do it there. Although if transportation is going to be an issue, she could do it at any provider in Sedgwick. So I'll let you coordinate that, Mr. Bales.
Thank you, Judge.
Is there anything further I need to address today?
Not on behalf of the city, Commissioner, thank you. Nothing from defense.
All right, thank you. Thank you, Ms. Brown, for your appearance today.
Yes, sir. Yes, Your Honor.
Yeah. It's in person, right, right down for you. Yeah. You see the drug and alcohol evaluation, have your provider send me a copy. But sometimes folks are not the best about doing that sort of shit, so make sure you bring a copy too, just to cover everybody, just in case. All right, anything else I can do for you, sir? You're free to go. A good day. Judge, I'm gonna need a moment with Mr. Hallowell.
Did we deal with Miss Neal?
Miss Neal, I haven't seen her yet, Judge. I'm going to,
Okay,
once I have dealt with Mr. Hallowell, I'm gonna see if I can't get a hold of her.
that's fine. I'll take up Mr. Dillon's cases. So whenever you're ready, if you want to come back in. Mr. Dillon, if you've got some announcements, I'll take those. Who's that in the chair at the jail? Oh, Larry's running back downstairs. Oh, there's so much easier. Just send. We'll give Mr. Marchinsky a chance to get back in action. Do you have any informal announcements, Mr. Dillon?
Yes, Your Honor. I'm just going to be in the case of Tasha Lasha Owen, I'm going to be requesting a 2-week continuance for attorney prep time.
Okay, give me just a second. Two weeks puts us to the 27th. Is that the date you were thinking?
Yes, Your Honor.
Court will continue this to August.
Rude. Sorry. I'm so sorry, Judge.
Sorry.
Somebody left a note on my desk. I apologize. I thought I was muted. I'm sorry.
Court will continue this matter to August the 27th, 2026 at 11 a.m.
Yes.
We'll get the time right, Mr. Dillon, at the defendant's request. I didn't think your request for continuance was rude, though, Mr. Dillon. Just
It
for
was
the
not.
record.
I apologize for my
The
outburst.
proper word, Larry, isn't rude, it's objection, just so you know. All right, thank you.
Thank you. I'll speak with you later.
Who else do you have here? I get do we have Mr. Smith available at the jail? We'll take that one up.
Yeah.
This is SU 2026 CR 214, State of Kansas versus Jason Smith. State appears by County Attorney Larry Marchinsky. Mr. Smith appears from the Sumner County Jail and counsel Tanner Dillon in person. Do you have an announcement in this matter, counsel?
Yes, Your Honor. I haven't had a chance to visit with my client yet at the jail, and I'd like to have a chance to visit with him before we continue. So if I could get a continuance for 1 week for August 20th, that'd be greatly appreciated.
Court will continue this matter to August the 20th, 2026 at 11 a.m. at defendant's request.
Excuse me, Judge.
Did somebody say something?
Yeah, that's me, Mr. Smith.
Yes.
I'm not sure if I'm gonna be here because I'm waiting on KDOC to come get me.
Well, they're not going to pick you up until this case is resolved. But if you guys get something worked out and we need to have a hearing before then or a special setting, I'll accommodate that.
Thank you.
All right. Thank you. Mr. Cook just came in the courtroom.
if we could take up Mr. Bodnar
Oh.
first.
Oh, that's Mr. Bodnar. Okay.
Yeah.
This is SU 2026 CR 115, State of Kansas versus Joshua Anthony Bodnar. State appears by County Attorney Larry Marchinsky. Mr. Bodnar appears from the Sumner County Jail and with counsel Tanner Dillon. Do we have an announcement in this matter?
Yes, Your Honor. Mr. Bodnar and I would like to waive our right to a preliminary hearing and enter into an agreed upon plea deal with Mr. Marchinsky.
And what is the defendant pleading to?
He'll be pleading guilty to count 2 of the complaint.
And that's, is that the aggravated trespass charge?
Yes, it is.
Okay. Mr. Bodnar, you've heard the announcement of your attorney. Is that your understanding of what you're planning on doing here today? Mr. Bodnar, you understand that you have a right to preliminary examination?
Yes.
And at that preliminary examination, the state must prove to the court that the felonies with which you are charged were committed by you here in Sumner County, Kansas, and that there's probable cause to believe that you committed those felonies. You understand that if the state cannot meet this burden, the felonies would be dismissed and you would be discharged on the felonies. You might still be held for misdemeanors. You are further advised that if you have a right to be present at that preliminary examination and have the witnesses testify in your presence. You have the right to cross-examine those witnesses or have Mr. Dillon cross-examine them. You also have the right to introduce evidence on your own behalf, but you're not required to present anything. You understand the right to a preliminary examination and you desire to give that right up.
Yes, Your Honor.
Court will find the defendant has knowingly, willingly, and voluntarily waived his right to a preliminary hearing in this matter. Does the defendant desire a formal arraignment? Or does he familiar with what he's charged with?
No, Your Honor.
Mr. Bodnar, you have a right to have the charges formally read to you. Your attorney's indicated that you desire to waive a formal arraignment. Do you understand that?
Yes, Your Honor.
And do you understand the charges that you have against you?
Yes, Your Honor.
And you fully understand all those charges and your rights regarding that?
Yes, Your Honor.
Okay. Court will find the defendant has waived a voluntary arraignment. The indication is that he's going to, or a full arraignment, formal arraignment, that he's going to enter a plea to count 2, which is aggravated criminal trespass on critical infrastructure facility, a level 7 non-person felony. Before I can accept your plea, Mr. Bodnar, I must explain certain constitutional and statutory rights to you. If you do not understand any of those rights or have questions, you may ask me to explain it. If you wish to consult your attorney at any time during these proceedings, you may ask him to do so, and we can give you the opportunity to visit with him. You understand that you have a right to a trial by judge or jury.
Yes, Your Honor.
You understand at that trial, the state would have to bring witnesses to testify against you in open court, and your attorney could cross-examine those witnesses.
Yes, Your Honor.
You understand the state must prove your guilt beyond a reasonable doubt and that you do not have to prove your innocence.
Yes, Your Honor.
You understand that a jury verdict of guilty would have to be unanimous.
Yes, Your Honor.
You understand that you have a right to obtain witnesses to testify on your own behalf, but you're not required to present any witnesses.
Yes, Your Honor.
You understand that you have a right not to incriminate yourself and that you would not have to testify at that trial or plead guilty.
Yes, Your Honor.
You understand that if you plead guilty, you admit the allegations the state's making against you in the charging document. You will not have a trial and you'll be giving up your right to appeal any errors at that trial.
Yes, Your Honor.
You fully understand all those rights we've just explained?
Yes, sir.
And it's your wish to give up those rights and enter a plea of guilty.
Yes, sir.
And you've heard the plea agreement in this, and you understand that I'm not bound by any agreements they may have regarding recommendations and sentence.
Yes, Your Honor.
Okay. Has there been anything, any threats made or promises made other than what's been stated regarding your plea agreement to get you to plead guilty?
No, Your Honor.
Has anyone promised you that you'll receive probation or any particular sentence?
No, Your Honor.
And you understand that, and I asked you this previously, any agreement's not binding on me, and I'll do whatever I think is appropriate under the law.
Yes, sir.
And you understand the maximum sentence in this case?
Yes, sir.
Okay. That's up to 34 months. Have the services of your attorney been satisfactory?
Yes, sir.
Do you have any complaints about how he has represented you?
No, Your Honor.
Do you have any complaints about the way the courts have, or court personnel have treated you?
No, Your Honor.
Okay. Are you under the influence of any alcohol or drugs this morning?
No, sir.
Okay. And two, the charge, aggravated criminal trespass on a critical infrastructure facility, a level 7 non-person felony. How do you wish to plead?
Guilty, Your Honor.
State's allegation or factual basis for that is that on or about the third day of October 2025, the defendant knowingly and feloniously and without the consent of the owner entered into or remained upon critical infrastructure facility, that being a substation owned by Sumner County Electric, which was completely enclosed by fences and barricades, in there to strip copper wiring. Is that the state's factual basis? That was here in Sumner County. That's the state's factual basis for the charge.
Yes, sir. The substation here in Wellington or outside of Wellington. Yes, that would be the charge. Yes, sir. The factual basis. Thank you.
Mr. Dillon, you've had the opportunity to review discovery. You agree that the state has those facts?
Yes, Your Honor.
Mr. Bodnar, you agree that's the factual basis for me to accept your plea?
Yes, sir.
Court will find the defendant has knowingly, willingly, and voluntarily waived his rights to a trial and has entered a plea of guilty to count 2, aggravated criminal trespass. The court will find there's a factual basis for the court to accept that plea, and I'll find the defendant guilty of count 2, aggravated criminal trespass on a critical infrastructure facility, a level 7 non-person felony. State have motion on counts 1 and 3.
Yes, sir. Move to dismiss those counts with prejudice. Thank you.
Those charges are dismissed. We'll need to schedule this for sentencing and get a PSI. I think Mr. Bodner's had recent PSIs. Can we get this done in 4 weeks?
Yes, Judge, I would note that this does typically possibly trigger SB 123 placement. I'm not positive. I know Tanner and I talked about it a little bit. We might want to look at 6 weeks. We do have a PSI that's less than a year old from his previous case. But being a severity level 7, non-person crime, there is at least a tangential possibility of this being SB 123 eligible. So we would just need to make sure that we give us ample time for that.
September 24th. Does that work?
That'll work for me, Judge.
We'll set this matter for sentencing on September the 24th, 2026 at 11 a.m. Order the appropriate PSI, LSIR, any other documentation that's required. Is there anything further I need to address at this time?
No, Your Honor.
Not on behalf of the state, sir. Thank you.
All right, this hearing's concluded.
And then
Give me just a second.
I was just going to say you could take up Mr. Falsgraff's case next, or
You sure you need?
I need a moment to speak with Mr. Cook.
Okay, that's
So I
fine.
also realized that we left Houston hanging on 2 of his cases.
Houston just came back in, so we'll take up Mr. Bales's cases, or
Well,
remaining
the
case.
Good thing is my next one is an informal announcement, Judge. We're making progress on plea in Mr. Hollowell's case, but I need some more time. He's also got to have some time to put together an eval. Could we get that 10-1 date to give him 6 weeks to get an eval scheduled, paid for, and in our hot little hands?
Give me just a second. You said October 1st?
Yes, Judge. It would be September 24th, but as we talked about earlier today, I'm not.
Court will continue this to October 1st, 2026 at 10 a.m. at defendant's request.
And Mr. Marchinsky, we'll get you that evaluation as soon as we can.
Perfect, sir. Thank you.
And Mr. Bales, the last case I had for you is Miss Neal's case.
Make a phone call on that, and then I'll know what I'm saying.
All right. So now we'll jump to Mr. Falsgraff's cases. Mr. Falsgraff, you have some informals. I did see your email. I know you had.
Perhaps a couple preliminary matters. I don't know if Mr. Marchinsky had a chance to review those proposed agreed orders for continuance.
I have not, Austin. I'm sorry, brother, but we talked about it. Whatever you want is, I'm fine. I don't have any objection to anything we talked about yesterday. I'm sorry, I haven't had a chance to follow up on the emails yet.
That's all right. That'll take care of Mr. Isaacs and Miss Nicholson's cases. I believe those were the two.
And just for everyone's record, Nicholson was set over to, it would be 9/17 per the request to finalize diversion work, and Isaacs was just a couple weeks to August 27th.
I'm just going to make a note that the agreed orders are to be filed. Can you just e-file those?
I will.
Give me just a second. Not a ton of cases, but enough that it's not easy for me to navigate here. And then you have some informal announcements,
I do, Judge, and I
whatever order you want to take those
Try to
up in.
take
You've
the
got folks here. so-
ones that are here. I do have Mr. Matthew Moon here. That will be an informal announcement. Judge, per the bond request, he has been following up with the VA. I've been working with the county attorney. We're going to get some releases signed so we can track that and kind of see if this is what route this is going from here, but he's been making great progress.
What, are you wanting to set this over to a specific date? How much time you think you need?
Okay, get to scheduling it. In the interim, Judge, if we could do 3 weeks.
That'd be September 3rd.
Does that work with you?
I think that's 3 weeks.
That'd be perfect, Judge. Thank you.
Continue this matter to September 3rd, 2026 at 11 a.m. at defendant's
And-
request.
Your Honor, from my side of things, if she is willing, I would ask Ms. Clodfelter to come down. I might even have some chance to chat with her this morning. It looks like she's here with Mr. Moon.
Yes.
Our discussions and what I plan on doing is going to be largely dependent on my conversation with her. So I'd like to get an appointment scheduled, or if she has time this morning, I could probably talk to her before lunch.
All right. You heard that, ma'am. You just go down to his office. It's out the door right here.
Sure. So. Yeah, for sure. Just a release, and that's the word you need to remember, release to my attorney, and then you've got my info. Okay, appreciate you.
What's your next informal?
Judge, I have Mr. Blake Moles, and I didn't anticipate him being here today. I'm retained on that case. I received an email Sunday that the diversion checks are coming with a finalized diversion agreement. He's been in contact with me. I would just request 3 weeks to that same third date as a control date, although I don't anticipate it being
Did
necessary.
you say he was here?
No, Judge, he's not here.
Okay. That's fine.
I don't have any objection, Judge. We had discussed it was going to be for continuance to get that diversion wrapped up, so I don't have any objection to that.
What was the date again, Mr. Falls?
The 3rd of September.
Okay. Court will continue this matter September 3rd, 2026 at 11 a.m.
Yeah, you good, man?
We're just juggling people everywhere here this morning. Mr. Bales, you have an announcement on your last case. Miss Neal, that's SU 2026 CR 113. State appears by the County Attorney Larry Marchinsky. The defendant does not appear, but counsel J. Houston Bales does.
So this is a bit of an odd situation, Judge. Miss Neal has been caught up in a couple of our late unfortunate circumstances. She was one on 2 weeks ago when me and Mr. Marchinsky were scrambling, tried to move too quickly, get too much resolved all at once. So we continued her a week to try to resolve it, and then the water main broke, and apparently I was unable to communicate the court date to her, which is unsurprising because everyone's scrambling. She's still available. She wants to resolve this case. We just need to get her a new court date. I've had good contact with her today. So this isn't, she's not in the wind for me. It's just
Yeah,
An
last
unfortunate
week's
twist today.
circumstances run avoidable and 1 week's pretty quick turnaround. What date?
Judge, I believe we have this arranged to a Class C misdemeanor as our ultimate disposition here. I was hoping she would be here today, but I don't have any objection. And based on Houston's announcement that he's had contact with her today, 2 or 3 weeks or whatever we need to be able to have her opportunity to appear in person and get her done.
What date do you prefer, Mr. Bales?
I know it's a tight turnaround, but I've had contact with her today. Could we try again on the 20th? Everyone is motivated to get this done. I'm going to call her right now and communicate that court date, and I will literally be right back in here if she can't make that work.
I'm fine with that. And then if that doesn't work, just file an agreed order, setting it.
Yes,
We'll
Judge.
continue this August 20th, 2026 at 10 a.m. at the defendant's request.
Thank you.
Thank you.
All right. Okay, back to Mr. Falls Graff's cases. What other announcements do you have? That's Miss Bailey, is that correct?
Yeah, it sure is.
What are we doing on Miss Bailey's case? I think this was working through a diversion, maybe.
Yes, Judge, I had been posturing Miss Bailey's case for an application for diversion. We now have her in a position to where all the posturing's done. We just have to go through the diversion process. So I'm gonna have a meeting with my client, sitting down, going through, filling out the diversion application and having it get submitted to the county attorney's office.
What date do you want to set this to?
Given that Miss Bailey's been here with perfect attendance, I'm gonna request a little longer time than I normally would to help work through this with her. And hopefully, if there's a chance, we won't even need to come back for that subsequent court date. I would request September 17th for Miss Bailey's case. Is that one?
Court will continue this to September 17th, 2026, 11 a.m. at defendant's request to complete diversion.
Still have my number. How about you give me a call tomorrow sometime and let's work through the logistics together of how we're going to finish this all up, okay?
Yes, sir.
All right, sounds good. Thank you so much for being here. You have a great day.
What else, Jim?
Judge, another one, I don't anticipate being here, but I've spoken to the county attorney, Miss Angelica Bradley. I don't think she was able to take off work, but she has been in contact with me. I didn't have time to get an agreed order on file. Long story short here, she's approved for diversion, needs time to pay, has been cooperative with the county attorney's office and a lot of things. So with all that being said, for time to pay purposes, I would request the 27th. Well, actually, sorry, Judge. I'm going to give her a little more than 2 weeks. If I could do the 3rd, hopefully by then that's a payday and we're good to go.
No objection, sir. Thank you.
Court will continue this to September 3rd, 2026 at defendant's request to complete diversion process.
And then I have Mr. Blackwell on the.
Looks like Mr. Blackwell is here by Zoom. Is that an informal? Yeah, that's a new appointment for Mr. Fallsgraf. And Mr. Blackwell is present by Zoom. Announcement.
Judge, I've reviewed the discovery, spoken to my client about the discovery. It looks like we're potentially going with the diversion route. We need to get an application put together. I just sent him the email yesterday. He's been in great contact with me. I would request September 10th if we could.
No objection.
Court will continue this to September the 10th, 2026 at 11 a.m. at defendant's request to submit application for diversion. Okay. What do you have?
Judge, I have a Jordan Shaw, and I'm not seeing him here, but he did attempt to call my office yesterday. I do believe he left a message. I just did not have a chance to get back with him. I would note for the court, he's been here via Zoom every single time and remained in contact with me. Given that, and we're also tracking a much larger case out of Minnesota where all this PFA violation comes from. Given that he's been in contact, I'd request the 27th for him, and I will get a hold of him and tell him he has got to be here on the 27th via Zoom. He is in Minnesota, Judge.
That's fine. And Zoom's fine since he resides in Minnesota. I'll continue this matter to August the 27th, 2026 at 11 a.m. at the defendant's request. Looks like maybe you've got a Kylie McCatherine. I don't know.
Do, Judge, and I spoke to her on the phone yesterday. She told me she would be here.
I don't know who else.
I'm so brain dead. We had a 4-hour meeting yesterday, and I have notes, Judge, that I was dismissing that case. So let me review real quick. If that's the case, there's no need to do anything else, but let me make an announcement.
Sure.
So, and I'm sorry, Austin, I gotta remind myself why I said I was gonna do that.
You're good. Mr. Marchinsky, just based on my notes, this is the one that was the conspiracy to use financial card. It was either going to set for
With,
trial.
okay, right.
Yeah.
Your Honor, Austin and I did review this case fairly ad nauseum yesterday. After a discussion, review of my evidence and everything else, the state doesn't believe at this time that it would be able to meet its burden should the matter proceed to trial. In regards to Miss McCatherine, so the state is going to go ahead and move to dismiss without prejudice. I would advise I don't anticipate bringing it back at this point in time. Austin did a good job at advocating through the evidence for me, and I could see how she would potentially not be knowledgeable of the behavior that was going on around her. And with that idea and the idea that a jury might also find that, I am going to go ahead and move to dismiss. I am asking for without, but I don't think I'll bring it back.
All right.
And just as a note for the court, the individual who was using the card
Pled guilty.
has already pled guilty.
Yes, that's Mr. Bergman. I'm aware of that. All right, well, we'll dismiss that matter without prejudice. Oh, was that? Oh, that was the victim. What else do you have here?
Perhaps word to the formals, I believe, unless I'm missing something.
Which one do you want to take
Let's
out?
take Mr. Bell's case first, unless you want to go with the jail
That's
next.
SU 2023 CR 157, is that correct?
Yes, sir.
Okay, give me just a second. That is that case number. That is State of Kansas versus James Michael Bell. What are we doing in this matter? I guess state appears by County Attorney Larry Marchinsky. Mr. Bell appears by Zoom and with counsel Austin Fallsgraf.
Judge, I did a lot of highlighting in the email that gave a lot of background context as to where we got today. In the interest of the court's time, I won't go through it all again ad nauseum. Regardless, Mr. Bell did 597 days of credit for time served on 2 Class A misdemeanors. It is the county attorney and I's request, based on the totality of the facts and the circumstances that brings us here today, to modify the sentence to credit for time served, that 597, rather than a revoke and remand situation or a PV first, where he's looking at the remaining 133 days. I would also note for this court, he was pretty successful on probation for a chunk of time. It looks like we had I believe it was a driving while suspended issue that arose. Long story short here, Judge, he's only got $12 in a UA fee that was done on probation and outstanding fees and court costs with us. I guess it's just my take that he's done his time.
State's position regarding, so I'm treating this as your request to basically commute the balance of his sentence before we even address the PV, and I'm fine with proceeding in that fashion.
Whatever the court deems best.
Mr. Marchinsky, what is your position on what's being requested of me, I guess would be the question.
Judge, this one is interesting for me because my original plea offer with Mr. Bell back in November of 2023 was to recommend the court run his cases concurrently and grant him probation for a period of 12 months. Had the court followed my original plea offer, Mr. Bell presumably would have walked down his probation by now. I feel that Mr. Bell has not in any way violated his original plea agreement with me that we entered into. So I believe that formally and ethically, I am still bound by my original plea agreement, which was to recommend a 12-month underlying sentence suspended to 12 months of probation. Under those recommendations, had the court originally followed it, Mr. Bell would have long ago served his sentence in full. I believe I am still bound by my original recommendations from November of 2023. And so that's essentially, I would say I have no objection because I think that Austin's request falls within what I am ethically bound to ask the court to do based on the agreements that I made. And again, Mr. Bell has in no way violated his agreements with me. So I feel like I'm still ethically bound by my recommendations from November of 2023. And had the court followed those, then Mr. Bell would have already walked this down. So my position formally would just be no objection with that caveat or with that explanation.
Okay. And it looks like his probation would have been up, but for the motion to revoke based on new activity in Sedgwick County, but no other. It's based on new criminal activity in Sedgwick County, and I guess an arrest maybe. Looks like he served over 3/4 of his sentence. I'll just commute the balance of his sentence. I'll commute the $12, and if he's convicted in Sedgwick County, they'll be dealing with him up there.
Thank you, Judge.
All right. Thank you. This hearing's concluded.
Thank you, Your Honor. Thank you, Austin.
What about me?
Thank you, Mr. Marzinski.
You're
Here you are.
fine. I'm
Good to
just
see you, sir.
joking.
Thank you very
I'm
much. I
just
appreciate
joking.
it, man.
Rude. Rude.
James, if you have any questions, feel free to call, okay? You're free to
I
go.
will. Thank you. Thank you, Austin.
I'm just making a quick note of that.
And Judge, just for the record, I would ask that you order Mr. Paulsgraf to prepare that order.
Prepare the order.
His motion, his client, my girl's busy, so.
That's fine. It's your motion. You made orally without written notice, and you're going to do the order, Mr. Falsgraf. Who do they have in the chair now? That looks like Mr. Shoemaker. This is SU 2025 CR 77, State of Kansas versus Brett Allen Shoemaker. State appears by County Attorney Larry Marchinski. Mr. Shoemaker appears from the Sumner County Jail and with counsel Austin Falsgraf. This is a motion to revoke probation. Is that correct?
That is.
It is, sir.
What are we doing, Mr. Falsgraf?
Judge, after conferring ad nauseum with the county attorney, with my client in custody, it is my belief that we're prepared to stipulate to PV second, that being for the failure to report, the failure to give UA, and the failure to complete the BIP assessment. The agreed disposition when it comes to that time is for a 30-day jail sanction, of which to today he's served 29 days of. It would also be an added recommendation from the state, which I agree with, that my client is to receive a new drug and alcohol evaluation and must complete recommendations of said evaluation. And I'd be prepared more to speak once we get to that time.
Judge, from our side of things, I do want to make clear that Chris Hollis's recommendation is for revoke and remand. This is a second PV with very similar allegations to the first PV. But Austin, as he always does, advocated very zealously on behalf of Mr. Shoemaker. I would state from the state side of things that I haven't had any contact with Rachel Shoemaker, who's his alleged victim, at least as far as the underlying issues that I was concerned with and the facts of this case. There haven't, I mean, obviously the violations are what they are, and I don't excuse them. But Austin and I did discuss this ad nauseum, and I believe that it would probably be better for the community and the state for Mr. Wolcott to, I'm sorry, for Mr. Shoemaker to work through a treatment program. So I am asking the court to impose new conditions that would help him work on his sobriety moving forward. But after our discussions and looking at these things, I guess what I was most concerned actually was the BIP. Our first PV a few months ago, he hadn't completed the batter's intervention program. He had done several sessions but hadn't completed it. I didn't get any records like that this time, so I'm not sure exactly where he was at in successfully completing the BIP. Again, last time the report showed he'd done like 6 or 7 sessions, but he'd missed a few, so he was discharged for missing. This time I didn't get that report, so I don't know how far he got into that. This case was a fairly, to me, significant domestic incident between Mr. and Mrs. Shoemaker. So I think that BIP is a very appropriate condition of the probation. But in looking at the facts here, Austin's, again, zealous advocacy on behalf of Mr. Shoemaker. I am asking the court to consider maybe something besides revoke and remand. Again, I had advised I was going to ask for a stiff sanction, which when Austin and I first talked about this a few weeks ago, I had said 30 days. He is right. When we were calculating jail credit yesterday, I think Brett's been in now 29 days, I want to say. So he has, That's where I'm at, Judge. Again, probation, I do want to say, and you can see the court's filing or Chris's filing that he is recommending revoke and remand, but from the state's perspective and talking to Austin and, um, I'm willing to give, from my perspective, I'm willing to give Mr. Shoemaker one more opportunity to try to make it right. So I am recommending a stiff sanction. Again, formally, Austin and I's recommendation is 30 days. Defer to the court what you think is appropriate. But just again, I think what I told Austin is I was going to very zealously ask you to reiterate to Mr. Shoemaker the importance of getting the BIP done, either making a new condition of probation, which is kind of redundant because it's already in there. But this is a critically important aspect of his rehabilitation. And so that's what I have, sir. Thank you.
Mr. Shoemaker, you've heard the announcement of your attorney, the intention to waive a right to a hearing. Is that, and admit the violations, is that accurate as far as what you're wanting to do here today?
Yes, sir.
And you understand, as I've indicated, you have a right to a hearing in this matter, and that at that hearing, the state would have to prove that you violated probation as alleged. And you'd have the right to see the state's witnesses they present. You'd have the right for Mr. Fallsgraf to cross-examine those witnesses. You'd have the right to present evidence and witnesses on your own behalf, including the right to testify on your own behalf, but you cannot be required to testify on your own behalf. You understand that by entering this stipulation, you're giving up all of those rights to that hearing?
Yes, sir.
And even though there may be agreed recommendations, I'm not bound and I don't have to follow those recommendations. You understand that?
Yes, sir.
Okay. To the allegation that you failed to report on March the 27th, 2026, do you admit that violation?
Yes, sir.
And it also says that you failed to report for a random UA on March the 24th, 2026. Are you admitting that violation?
Yes, sir.
And the third allegation is that you have not, you failed to enter and complete a batter's intervention program as ordered by the court. Is that accurate? You're admitting that?
Yes, I have not completed it yet.
Okay. Court will find the defendant has knowingly, willingly, and voluntarily waived his right to a hearing, that he's entered the admissions to the violations in the affidavit, and that he has violated probation as alleged. Mr. Orchinsky, you've made a pretty extensive recommendations. Do you have anything to add to that?
I'm sorry, Judge. I should have waited till dispo as opposed to,
Okay.
but no, I don't have anything.
got him.
Thank you.
Mr. Fallsgraf, do you have anything you need to add?
Yes, Judge. After speaking with my client in the jail, I mean, I just asked him bluntly, what's going to be different this time? Why is it we had these issues last time? What's the difference this time? I'm aware that there's some significant financial strain on my client, albeit he is a HVAC technician, skilled technician, had made pretty good money. These run-ins and issues have kind of set him back financially, on top of a child support payment that reflects how he was doing when he was doing very well. With that being said, there was a great deal of financial strain. There is a cost associated to the BIP courses. And it was a situation where it was food for the next couple of days or attending BIP. And yeah, probably not the right choice. Probably should have skipped the meal and gone to BIP, but that would be an issue there. I understand that doesn't excuse the failure to report in the UA situation, but my client primarily has been up in Wichita when he initially had probation there, and I understand unsuccessful. Fully understanding of the unsuccessful nature when he initially was in Wichita. But now with it being here, it created some issues regarding transport and getting down here. The Uber cost being every bit of $60. Last time I looked, it was closer to $90 to and from Wichita to here. There were financial strains that resulted, or at least helped contribute to the result we see here today. I do believe it'd be in the best interest of justice and for my client to complete the BIP assessment, go through the coursework, do what he needs to do, rather than say, here, Mr. Shoemaker, do the remaining of your underlying sentence, and you should figure it out next time. So that's my position, Judge.
Mr. Shoemaker, this is your opportunity to make comment to the court if you desire to before I make a decision. Do you have any comments you would like to make for me to consider?
When my plan is when I get out of here to go to a sober living house or an Oxford house. I have 4 different jobs lined up. One of them will take me to get back on track with financial issues. And that's all I have to say, sir.
Okay. Well, this case, I obviously remember this case because you were doing pretty well on probation and there was a motion to modify your probation regarding BIP at the end of last year. And I granted that because my recollection was you had employment opportunities out of the state. You were doing an online BIP course. You'd made progress towards completing that. And there was some back and forth on whether you should be able to do BIP online or in person. And we made some modifications to your probation. And then within just a few weeks, you violated probation by failing to report to your CSO in Sedgwick County. So you'd actually had your probation transferred to Sedgwick where it was easy to report, and that's a courtesy supervision, and then failed to report. And then here we are back with another failed report, understanding that your own actions made it more difficult for you to report. You also failed to complete the BIP program that I made exception for you to stay into. And you were discharged from that. So I appreciate where we're at here. I appreciate and understand court services basically saying, how can we continue this? And we're just recommending revoke and remand because you can't, if you don't report, we don't know how you're doing on probation. And the 2 things you need to do is report and complete BIP, and you haven't done those. And this is the second revocation for that reason. I'm inclined to agree with the thought process that you're better off getting treatment. The community's better off with you getting an assessment and doing what you need to do so that we don't have future problems. And so I'm inclined to agree with that. But I'm also in my head questioning what's going to be different this time when we've created such a difficult circumstance for yourself. So that's what makes this decision a little bit tough for me is I don't like spinning my wheels and giving you probation and then being back here in a month or 2 or less. So Mr. Shoemaker, I'm going to ask you this bluntly because it's my opportunity now to modify your sentence. I can obviously revoke your probation. I can remand you to serve the remainder of your 6-month sentence, which you've done a little bit of time because this is the second violation. So you're at about 40 days, maybe, I think, if my calculations are right. I could revoke and remand you, and I could even give you a little break and commute some of that sentence. Or I can consider what's recommended to me, leave your sentence alone, and reinstate your probation after you've done some sanction. I haven't decided if that's what's right, but which would your preference be? Because if I revoke and remand you and commute part of your sentence, you're out of jail sooner and you're not on paper. And you can do all the things that you've told me you're going to do with regards to sober living and stuff without me telling you to do that. Or if I consider the other alternative that you're requesting is that I don't give you any break as far as that goes and just let you back out on probation. What would your preference be?
Go back and do probation and finish the BIP class.
And the state's recommending the 30 days, which would be a reinstatement basically tomorrow. Okay. I'm going to follow the recommendations. I'm going to reinstate your probation effective. You'll be released at 9 a.m. tomorrow, and you'll report to court services at that time. You're going to report immediately after being released from the jail. Your probation is going to be for a period of 12 months from tomorrow. You're going to be ordered to obtain a new BIP assessment and follow all the recommendations.
May I ask a question?
You can ask a question, yes.
How long do I have to get that assessment done? Can I have
absolutely quickly as possible, because I would like you to complete everything you need to complete and successfully terminate your probation before the 12 months is up.
Yes, I was gonna ask for a week or two so I can get a
Well,
pay.
no, that's fine. I think that's reasonable. I think
Oh.
as long as you get the assessment done within the next few weeks, that's fine. The
Okay.
important thing is that you report to probation tomorrow, that you set up a time to report, you continue to report, you update them on the progress with getting a BIP assessment scheduled, that you stay in touch with them and keep them updated on your progress through not only the assessment, but through whatever treatment recommendations BIP that assessment has, and that you report, because it appears that that's the biggest issue is reporting and doing the BIP. So I expect those to be done. But yeah, a few weeks is fine. I think what you do is you get out, you report to probation, and then you keep them updated on when you have it scheduled. You
Okay.
understand that?
Court services is probation, is that correct?
Correct. Court services offices here in the courthouse, you need to report immediately after being released from the said Sumner County Jail.
Yes, sir.
All right?
Yes, sir.
Because of the financial circumstances and the BIP, I'm not going to assess attorney's fees against you. This is it, though. You miss an appointment, you just might as well say, Judge, I just want to serve my time, my full sentence. So this is it. All right?
Sure.
If there's anything further, this hearing's concluded.
Thank you.
On behalf of the state, thank you.
Thank you.
That leaves you, Mr. Wolcott. Give him just a second. And the last one I have for you, Mr. Falsgraf, is SU 2025 CR 217, State of Kansas versus Chad Ellsworth Wolcott. State appears by County Attorney Larry Marchinsky. Mr. Wolcott appears from the Sumner County Jail and with counsel Austin Falsgraf. What's the announcement in this matter?
Judge, I would have loved to have a resolution by today. This is only my client's, and I say only, but it's his 14th day in custody. The state's recommendation is going to be revoke and remand. My counter request at this time, if I was to proceed forward today, would be a 30-day jail sanction. So I don't believe by requesting a continuance, I'd be prejudicing my client in any way. Given the significance of what all is going on here, it'd be my preference for me, A, to get some time to look into some things, and then B, maybe potentially do this on a special setting, given the severity of the 24 months hanging over my client's head.
And did you want to go ahead and special set it now? Do you want to
If we could.
just set it over for control purposes and then special set it? How do you want to handle it?
Just so it doesn't slip through the cracks, Judge, if we could special set it now, that'd be my personal preference. And I defer to everyone else. My next week's looking pretty open.
Mine isn't.
And I could even do.
My preference would be a few weeks. Give me just a second. Could we do late morning on the 31st? Mr. Falsgraf, are you available?
I think I can make that work, Judge.
Does 11 o'clock work?
Yes.
We'll set this at 11 o'clock on August the 31st, 2026 at defendant's request.
And at this time, I don't anticipate that being a contested hearing. If something were to change, Mr. Martinsky, Your Honor, I would let you know as soon as I know.
We've got time that morning. I mean, it's going to have about an hour. If that happens, just let us know so I can make a note. And obviously, Mr. Marchinsky would need an opportunity to issue subpoenas.
For the allegations, it would just be Bruner, I think. So just let me know as soon as possible, but we'll make it work. It'll be fine.
All right. This hearing is concluded, and I believe that's all you had.
I think so.
All right. Thank you, Mr. Falsgraf. Mr. Dillon, you're up with your last one. This is SU 2026 CR 197, State of Kansas versus Ronald Wayne Cook. State appears by County Attorney Larry Marchinsky. Defendant appears in person with counsel Tanner Dillon. Do you have an announcement in this matter, Mr. Dillon?
Yes, Your Honor. Previously I had spoken with Mr. Markinsky and, I thought we had managed to come to a deal on this, but after speaking with my client, he has a few additional concerns, that I would like to address with Mr. Markinsky. So I'm going to be requesting a 2-week continuance.
I believe that's the 27th. Is
Yeah.
that right?
Yes, Your Honor.
Does that,
Oh, my client stated that that's the date that he's scheduled to be evicted from his home. So,
we need to pick a different day?
yeah, we could move it out another week if that works better for you. Okay, if we could do 1 extra week on
That
that.
would be September 3rd, I think.
Yes.
We'll continue this matter to September 3rd, 2026 at 11 a.m. at defendant's request.
Thank you, Judge, and thank you,
All
Mr.
right.
Markinsky.
Thank
Of
you.
course, anytime, Tanner. Thanks.
And we will be adjourned for the morning.
Yes, sir. Thank you.